Welcome to Channel 17, the Town of Colonie Government Channel.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our legal system and our justice system, and how they relate and intersect with the citizens of the town of Colonie. Today, we're truly fortunate to have a special guest who primarily practices in the area of medical negligence. Many of us or our families have been concerned often about healthcare delivery system and the impact it has had on our families. And oftentimes it gives rise to a variety of questions about whether an attorney should be consulted in considering how the course of care had been conducted. And today we're joined by Patrick J. Higgins, who practices with one of the most preeminent personal injury firms here in the Capital Region, Powers and Santola. Pat, thank you very much for joining us today.
Thank you, Judge. I appreciate being here.
Well, we're thrilled to have you, and of course many people have stopped me on the street and wanted us to air some information about medical negligence. And it's a big issue for many people, and of course oftentimes it makes headline news,
right,
and sometimes maybe sensationalized to some degree or another. But underneath it all, there is a very human side and a very emotional side to a variety of these issues. And we're very pleased that you can share that information with us. But before we get into what is medical negligence, I'd like to know, and I know our viewers would like to know, a little bit about you. And tell us where you went to law school, and I know, of course, that you live here in the great town of Colonie. Where'd you go to law school?
I went to law school in the University of Buffalo, graduated in 1984, and then I'm from Long Island originally, so I went back and I got a job down in New York City for about 5 years. And then I always liked upstate. I've always liked the Adirondacks. My parents have had a house up in Wells for over 30 years, and I just wanted to come back up here, and got tired of the subway. So I came up and met my wife up here, and I've been practicing up here since then.
Well, of course, your wife comes from a very well-known family, Mary Ellen Panetta. And of course, many of us recall the famous restaurants that the Panetta family maintained here in the Capital Region. And of course, I recall Broadway and Menands as my first visit to Panetta's on the father-son dinner through my grammar school many years ago.
Right.
And it's such a great family that did so much for other families in the community while in the restaurant business. And we're thrilled that all of you live here in the town of Colonie, and you have 3 children.
Yes, I have Sean, who is 13, Danny's 9, and Katie is 11. And they all go to, Danny's going to Saddlewood, and the other 2 are at Leishakill now.
Well, that's fantastic. Now, did you always want to get involved in trial work?
I did, and you know what they say, be careful what you ask for, you may get it. So ever since I was in law school, that's all I ever wanted to do. And it took me a while, you know, the big firm in New York, you know, I had to move off there, and then I went up here, and I got there. So I've been trying cases for a fair amount of time.
Well, I know our viewers are very interested in understanding more about medical negligence. Pat, what is medical negligence?
Basically, it's medical negligence. It's not very much different in conceptually from a case where you have, let's say, an automobile accident, somebody is not exercising reasonable care. Now, the only difference in this case is that, of course, you have a physician who is an expert, and you have to basically establish what's called medical negligence. So to put it in layman's terms, basically, medical negligence means that a doctor is not exercising the reasonable amount of skill that other doctors in his community or the national standard would. In other words, he's not doing what reasonable doctors would, and that causes injury to a patient. Now, a mere complication, in other words, if let's say you have your husband is sick or your wife is sick and she goes in for an operation and it doesn't work out well, there's a complication or the patient dies. I mean, that doesn't mean there's malpractice. I mean, the doctor could have done everything possible, and it may have just been that, sometimes things happen during surgery, which doesn't mean there's been a medical error. The other thing is if a doctor has 3 acceptable choices, let's say you've got a broken bone, and the doctor says, well, he looks in his textbook and he says, I can put a rod in, I can put a plate in, or I can do an external fixation. And all 3 of these are okay. And he goes with the middle one, because he's had good results with that. And it turns out that the bone doesn't form, you get a non-union, develops osteomyelitis, which is a bone infection, requires an amputation. Okay, is that malpractice? No, it's not, because he chose from one of 3 medical acceptable alternatives. And that's called the medical judgment rule. So that's not malpractice. And I think part of what we do is when people come to us, our job is to educate them to what is medical malpractice and to let them know that, that maybe this isn't medical malpractice. And at the same time, we want to review the case to see if it is, then we want to advise them of that accordingly. But we end up turning down about maybe 9 out of 10 cases, ultimately, because a lot of people don't really understand what medical malpractice really is.
I have found sometimes that in just my daily life that oftentimes the healthcare delivery system doesn't do an effective job of communicating. And I had my dad in a local hospital for the past week, and I just brought him home yesterday. But in that, I'd go down and visit him in the hospital, and it seemed difficult to get information about, okay, you've tested him for a variety of things. What does the blood work show?
Right.
What are you seeing here? What are you treating him for as he's here in the hospital? And while in the end, I believe I got the information, the healthcare delivery system sometimes doesn't realize that people are very anxious and would like to know some information, and all I want to know is what they know. And it's not always easy, and I bet that sometimes people come to you because they believe they haven't gotten answers. Do you feel that to be true?
Oh, absolutely. Most or a good percentage of the people that come to us, they kind of come to us, they've got this look on their face. Maybe their son has just been diagnosed with a bad condition, or maybe their father has just died suddenly, or something. And the first thing they say is, well, I don't know what I want to do, but I don't know what happened. And they literally don't know what happened, and they can't get any answers from the doctors for whatever reason. And I'm not casting aspersions or anything. I'm just saying they literally don't know what happened. And their emotions are very raw, and sometimes the doctors and the nurses may be kind of abrupt, or maybe their bedside manner is not that great, or maybe the doctor's too busy, won't return phone calls. And these are people. They're not medical professionals, and these are loved ones who go into the system, and they should at least find out what happened. So they come to us, and we'll say, well, okay, we don't know if it's medical malpractice. We're not saying it is, but we'll take a look at the records, and we have them come in. We take a very detailed history from them, because many times they don't understand what's really important, and they'll just they'll focus on one thing, and that one thing ends up not to have to do with anything, but it's what happened 3 days before that they don't think is important,
right, that
we are listening to, and then we'll get the records. We'll get an authorization. We'll send out the records. And we will basically gather all of the medical records and then start taking a look at them. We'll also do medical research. We'll consult with experts. And then, at a certain point in time, maybe we'll have all of the attorneys in our office. We'll sit down and we'll take a look at this case. And we'll say, well, here's this case. What do you think about that? And, we have John Powers, Dan Santola of our office. They've been practicing 30 years. They're very, very experienced. And then we'll have the family in and 9 times out of 10, we'll tell them, you know what, this isn't medical malpractice, but here's what happened to your loved one. And a lot of times that's all they're looking for. And particularly, they will feel a great amount of guilt. If something's happened, they will say, if only I'd gotten Johnny to the doctor on Tuesday instead of Wednesday, he might be alive now. Or if I just made that doctor come in, or I'd taken that test, or I had done this, he'd still be here, or she'd be here. And we can sit them down and we can say, listen, we have your records. We've talking to, let's say it's a cardiologist case, we've talking to a preeminent cardiologist in the field. He's looked at all your records, and you know what? It was just John's time. And what you did didn't have any effect on this. It's not your fault. It's not the doctor's fault. The doctor, it's a bad result, but the doctor didn't commit malpractice. And we'll sit down with them for as long as they need. We'll talk to them. And hopefully at the end of the process, they'll know that, the malpractice is not where they should be going, but they have some answers. And maybe that'll give them some peace. And that's a big part of what we do. And we, personally, I think that's something of value for us to do that. Now, we also give them their records. So if they don't feel comfortable with our,
Sure.
what we're saying, they can go somewhere else, but at least they've been advanced, so now they have their records.
So you find that your firm spends a tremendous amount of time reviewing files at the request of potential clients, and in fact are able to give them information which can settle their own lives, and and by explaining to them that there really isn't any medical malpractice as far as you see in this particular matter, but it helps settle them. And
Right.
the comfort that you give them there too is really a community service in and of itself. It
Yeah.
can be.
Yeah, well, I think that I think we're all officers of the court, and I think that we when we bring a case, you need skill, you need passion, and you need determination, because these are very highly defended, highly skilled defended cases. So if you're going to bring a case, you had better be sure this is a case, and there's not really much to talk about in the case. And you're going to have experts who are going to be very, these cases take 3 or 4 years. They're emotionally draining for the clients, for the attorneys. They're very expensive because of all the experts you need. So it's not like you just, on a whim, just say, well, you know what, I think I'm going to take a medical malpractice case today and just start it because it's Tuesday. I mean, that's not how things work. And part of what we do is letting people know that.
Now, are doctors compared to a community standard or a national standard? When I was in law school and we touched on the issues just briefly at that particular time, there seemed to be a focus on community standard, how that doctor compared to other doctors in their community. And there also seemed to be at the time some type of medical malpractice panel, that any case that contemplated going to court alleging medical malpractice had to first be reviewed by a panel. Any of that still in existence today?
Well, yes and no. Let's take the second one first, the panel requirement. That was back in the mid-'80s, and again,
Thanks for dating me.
No,
I
that's
appreciate
okay.
that, Counselor.
Well, maybe it was in the mid-'90s. I don't know. But basically what that was an attempt by the legislature to basically try to screen out or basically have the doctors have some say in terms of these cases. And what they found, without going into too much details, is it just didn't work, because even when the plaintiffs prevailed there, it didn't reduce the amount of cases going into the court system, so it was just kind of superfluous, or it didn't help. So what they do have now is they have a requirement for certificate of merit, which means that unlike other cases, if you want to bring a case against a doctor or a medical provider, the attorney has to sign a written statement saying, I have conferred with an expert in this field, and this expert has assured me that this case has merit. So again, and for people in this field, you're doing that anyway. I mean, you're not going to start a medical malpractice case unless you've talked to all of your experts, and this is one of those cases that fits your very tight criteria. So, but that most people in the public don't realize that before you start a med mal case, you have to have a certificate of merit. and you have to have an expert review the case for merit. Now, in terms of your second question, which was the community standard rule, what that means is earlier, like maybe 20 or 30 years ago, and again, you probably learned this in law school when you know.
That's right.
I'm not saying the community
That was
standard
when Albany Law School was a one-room schoolhouse, by the way.
But what the rule evolved because what they were saying was that the judges were saying it's not fair to, let's say, if you have a small rural doctor who's practicing in, I don't know, rural town USA, it's not fair to compare him to a doctor at Johns Hopkins or who does nothing but research and is surrounded by all the latest medicine. So that was the community rule. You have to consider that rural doctor in the jurisdiction where he is. Mm-hmm. And that still exists theoretically, okay? But in practice, most of the physicians nowadays are board certified. And that means they have to usually take a written or oral exam, which is administered on a national basis. And that kind of provides a uniform standard for those people who are board certified. So in this particular, if the physician is board certified, then it's a national standard. In other words, if you're board certified in gastroenterology, treatment of the gastroenterology tract, it should be the same in San Francisco as in New York, as in Plattsburgh, as in Miami. Okay, if you're not board certified, then the community rule still could apply, and that's something that we certainly have to look at.
Well, it seems clear to me that so many people that come to you for advice, you pare it down to almost 10% of those situations that are brought to you are actually, you believe, actionable, which means that for the most part, merely because the outcome wasn't what was sought doesn't necessarily mean that a physician has committed medical negligence.
Correct.
In fact, obviously our community is blessed with so many talented physicians who routinely care for the lives of all of us in the capital region, and that's to our benefit. Is intent an issue? In my business, I often, as a judge and also as a private counsel, many of the criminal statutes are involved with intent.
Right.
And that the people must prove that you intended to do this or that as an element, a necessary element of the alleged crime. Intention, does that have anything to do with it in a medical malpractice case?
Generally, not.
Okay.
And because these are compensatory cases. In other words, the juries sometimes think that the doctor is going to lose his license or the doctor is going to get punished or something like that's going to happen. These cases are only to replace what has been lost. That's all. The fact that, and most of these times, the doctor is not going to go into an operation saying, you know what, I'm going to go sever the carotid artery today. I mean,
right.
That's not going to happen, or I'm going to not return this phone call because I think someone's going to get seriously hurt. So intent is not really, there are cases where you have punitive damages, but for the most part, in the more common medical malpractice cases, intent is really not a factor in these cases. It's simply a failure to exercise reasonable care. And that's really, intent doesn't factor into that.
So it doesn't necessarily mean, even if a verdict is returned, awarding compensation to a plaintiff, that the doctor loses his or her license?
Oh, I would say, in my experience, I've never ever seen that happen.
Okay.
It's just, they have no relationship, basically, for the most part.
Right.
That's not really, doctors losing their license is handled by the state of New York under what's called the Office of Professional Misconduct, and that really has no relationship or tie-in to the civil jury system.
Now, oftentimes, the cases go to trial. How many of the cases that you agree to take actually go through verdict or through trial?
Well, it seems like in our particular firm or our area, medical malpractice is a very fair amount go, because a lot of the times the doctors will not want to consent to settlement, or for various other reasons, or maybe the two physicians or the hospital are not agreeing as to who's responsible, so they need to have that resolved by a jury. But we try a fair amount of cases, and what that means is you can never take one of these cases just saying, well, this case is so bad, they're going to call me on the phone in 3 weeks and this case is going to be over.
Right.
That is the absolute, I don't think that's the way to handle any case, but certainly medical malpractice, you're not going to survive, and it's a very highly specialized, skilled environment, and the defense attorneys are very good. The insurance carriers are very specialized, and the doctors are they're strong, passionate people, and you have to, if you want to take these cases, you would better know what you're doing, and thinking a case is going to settle, just because it's really bad, maybe it will, but you can't bank on that. So you have to basically put every case together as if it's going to try.
And how many cases have you tried in your practice with Powers and Santola? Too many to count, probably.
A lot. Fair amount.
Is there usually a lifespan of the trial from beginning to end? Can it just be 3 to 5 days, or can they go on for weeks? Or?
Oh, they can go on for weeks.
Right.
I tried a case involving an infant who was brain damaged during the labor and delivery. That one for 3.5 weeks. I know my partners have been on trial for 4 weeks. That's not unusual. It's unusual to do a medical malpractice case. I would say a week it's quick. I would say maybe 2 weeks is more, 2 to 3 weeks is more in line with that. And, a lot of it depends on the judge. And the judges these days are getting a lot of pressure to really, really move things along. And, you and I talked about that a little bit, but trials are very important things for the doctors, for the patients, for the attorneys. It's not like, we prepare for months for these things. And, so it's a little it's worrisome sometimes if, you don't have enough time to pick your jury, and these people only have one shot. So you have to give them the best you got. And, so we like to try to we try to move as quick as we can, because the juries come from a visual society. I mean, they've got the Apple iPod, whatever. They've got everything, and they walk in and, they expect to see a 25-foot television screen, and they want it done. And they want it done now. They got jobs. They want to go back to their family. So we try to move as quick as we can. But, 1 or 2 weeks is, I would say, very average.
And I know that opportunities during voir dire with potential jurors, or the ability for attorneys to ask questions of potential jurors to see whether they think they would be properly suited for their point of view,
right,
is limited. Stu Jones joined us some weeks ago, and he pointed that out, that the opportunity now to pick a jury is much confined by the court itself, because of the pressures on the judiciary too, right, trying to manage the caseloads.
Right, and again, I don't. The judges are under a lot of pressure, and they've got, I don't know, 200 or 300 or 400 cases, and sometimes attorneys can go on. If and they've got to set limits, and of course that's just the give and take that has gone on for some time, and I'm sure will go on. But jury selection is a very, for me, it's the scariest part of the whole trial, because you're up there with, I don't know, 20 or, usually the people in the back are there, but you'll be up there with, some people in the box, in the jury box, and, they have their own opinions, and, they're not afraid to share them with you. So you don't know what's going to happen.
Right.
I've walked into, how you doing? You know what, you people, and it's just, you're like, whoa, but it's what's good about
That's
it
true.
is because that's how it works. You get people in off the street, and that's who you need to resolve these cases. And you know what, if you can't stand the heat, get out of the kitchen. So.
Now, in a successful case, from your point of view, where actually an award is made by the jury, or a settlement is
right,
reached and a payment is made, oftentimes we see things in the newspaper where it looks large numbers are being awarded in certain types of cases, and but in actuality, all of the money doesn't necessarily go to the successful plaintiff. All of the money doesn't go to the attorneys representing that successful plaintiff. Sometimes there are others that get some of that money as well. How does that work?
Well, that's a very relevant question, particularly nowadays, because usually when you see these big awards in the paper, it's usually because you have maybe you have a child who's been injured at birth, so he's going to need medical, or she's going to need medical care, vocational care, round-the-clock nursing care, never work at all, and basically was not going to have a life for the next 70 years. So and the jury has to award that all in one shot. So that's a big number.
You bet.
But the other thing is that let's say Medicaid. If you have someone who's been injured by a medical error and they're in the hospital for a year because of that, and they don't have health insurance, Medicaid will pick that up, or maybe Medicare. And when the case comes around, Medicaid and Medicare are going to basically be tapping you on the shoulder and say, that $300,000, it's coming right back to us. And if that amount is, $4 million, it comes right back to them.
So actually, you become also, to some degree, a collection agent for the state and federal government.
Well, we don't like to think of it that way because, our job is for our patients, but
Absolutely.
that's what happens.
That's what in reality happens.
Oh, yeah.
And of course, your only focus is
Right.
your client.
But what we like, the way I can think about it is that at the end of the day, if I've represented my client, okay, and I have also gotten Medicaid or Medicare back $300,000 or $400,000, or I've repaid the state or the federal government, what I've done is I've shifted the burden of paying for this medical error to where it should be, the wrongdoer or the person who had made the error, as opposed to the government, the state and federal government, and the taxpayer, because ultimately that's where the money comes out of. So I'm okay with that. It makes it sometimes very difficult to get these cases resolved because, it's like there's a lot of people at the table. And it gets
right.
interesting, but, that's what we do. So.
Well, we have just a minute or two more. I'm sure that you have been part of a variety of significant cases that have left a lasting impression on you, too. Could you tell us about one right now, about a case that's already closed?
Yeah, and of course I won't mention any names either of
Sure.
the hospitals or but I like doing good things for people. I like to serve people, and some of these cases you walk away saying, this is a good thing. We had a 56-year-old woman who went in for a cardiac catheterization, routine procedure pretty much. She started bleeding from her femoral artery after the procedure. Again, a complication, not malpractice. It happens. They did a CAT scan at 5 o'clock. It initially happened in the morning. The CAT scan result came back. It said that basically, I'm paraphrasing, but there was significant bleeding going on internally. So that's a surgical emergency which has to be taken back to the OR immediately, cleaned up, or else the patient's going to go into septic shock and die. This report comes in at 8 p.m. to a hospital out on the Western Tier, and it sits there from 8 p.m. to about 7 a.m. Nobody does anything. The doctor never calls back. The nurses never call anybody. The radiologist never follows up to make sure that somebody's doing anything. She bleeds out or bleeds internally all night, and by the morning she's hypotensive, she's in septic shock, and she suffers, they do bring her back, she does live, but she suffers significant damages, and we got her a good settlement on the case, and I think that it didn't have to go to trial because everyone realized that this was a case that really didn't have to burden the jury system with. So that was one I felt good about.
And I know that earlier on we were speaking about another case that involved a young lady who had come into the emergency room, and she had appeared to be all the elements of possibly some type of appendicitis, and actually was not diagnosed that way. Could you tell us about that?
Absolutely. This was a case that actually, unfortunately, did have to go to verdict in 2006 in a county an hour or two south of here. And this is a very nice 32-year-old woman, went in, and she had a white blood cell count of 17,000, which is normal is 10,000, which means there's some type of infectious process going on. She had what's called a shift to the left, which again is an indication that there's something going on. The emergency room physician did a very cursory exam, told her she had bad menstrual cramps, and sent her home. 2 days later, her appendix burst and basically bathed all of her female organs in toxic material, rendered her sterile, And we had to take that case to the trial because the defendants, the doctor would not settle the case. The defendant's attorney wanted to settle it, the insurance company wanted to settle it, and the doctor wouldn't. So we ended up getting a very, very substantial verdict against that doctor. And by the way, he did not testify at trial. So.
Well, these are the types of things that certainly make your practice appropriate for the community. And of course, today we're joined by Patrick Higgins of Powers and Santola. And obviously, other than practicing law, you're engaged in a variety of other community activities. And maybe let us know what else you're up to these days.
Well, right now, I'm the president of the Albany County Bar Association, and that has been taking up a fair amount of my time. And we're working to try to get the courthouse is under renovation, so we're working to try to improve the courthouse for jurors. Last year, as you know, you were kind enough to assist us. We ran the Bike Safety Day with the local hospitals and the Town of Colonie Police Department, and we gave away about 170 helmets to children for free. Crossgates was in there, Fox 23, and it was just a wonderful event, Albany County Sheriffs, and it was good to work with the community, and it helped.
You know about that, too. You were nice enough to say that I participated, but actually this concept was hatched by you, and I bet it was because of the focus of your practice and seeing the dramatic effects of head injury and a way to protect our young people, and giving out to, how many hundreds of helmets did we give out?
179.
179 helmets.
169. And you're right, the way this came up was that a lot of the doctors that we had dealt with, and the same with us, by the time these children get to us, it's over. I mean, you can't do anything.
Right. Well, I think that that event, which was created by you, was a great success for our community, and also on behalf of the Bar Association. Anything else that you'd like to share with us about your other activities? I bet that you've been involved with your 3 children in some Little League and some other things.
Yes, I'm a former manager and coach of the Colonie Little League, and in fact, Danny he played last year, and I think he's actually, I hesitate to say this in Colonie, but I think he might be heading towards lacrosse now, and
Yeah.
so you know, he just loves it. So yeah, I mean, we've been trying to be as busy as possible, but you know, the legal practice and the Bar Association takes up a lot of my time, and I try to spend as much time with my family as I can. You know, when I'm not doing that. So.
Well, the town of Colonie is very fortunate to have you and your family with us, and no doubt that you're providing a significant resource for all of our citizens. And I wanted to thank Pat Higgins for joining us today and sharing some brief comments about medical malpractice. And I certainly look forward to reviewing the rest of the publication just out, called Representing the Personal Injury Plaintiff in New York. I'm Judge Peter Crummey, and thank you for joining me on Benchmark.